Ready, Mr. Durst? Would you like to reserve time?
Yes, I will reserve 5 minutes for rebuttal. May it please the court. First Financial Bank did not meet its burden to prove that Tailored Fund Cap LLC committed conversion for 5 chief reasons. First, FFB did not meet its burden to prove that Tailored Fund had a security interest in the relevant company's accounts receivable, and therefore Tailored Fund cannot have converted, a non-existent security interest. Second, Chapter 1309.332B of the Ohio Revised Code, regardless of whether there was a security interest, provides that funds transferred from a deposit account are taken free and clear of a security interest, which precludes conversion. Third, again, putting aside the security interest issue and the 1309.332B issue, Shining Knight and the Wexford companies, the relevant SOSNA entities, were expressly allowed under the loan documents to sell their assets, including their accounts receivable. Fourth, turning to damages, First Financial plainly did not satisfy the tracing statute or even their own stated theory of damages to prove that my client, Tailored Fund, was paid with proceeds of anything, i.e. accounts receivable, that First Financial Bank had a security interest in by their own very plain admissions at trial. And last—
Counsel, by my count, FFB has pursued 3 different damages theories in this case. The first one in the complaint sought recovery of the converted funds. The second one in the default judgment motion sought the loan balance at the time. And the third one in the summary judgment motion sought $3 million, the sale price. Which one of those controls the damages calculation in this case, or does something else control?
Well, so I'm going by what First Financial argues in its appellate brief, which is that what was converted allegedly was accounts receivable on the day the 2 merchant cash advance agreements were signed, March 23rd, 2020, before any money changed hands, and that the damages, they claim, were all the funds that were transferred to Tailored Fund. And so in the cross-examination of Tracy Farrell and in the discovery responses of First Financial Bank, when we asked them what their damages were, they were very clear that they were drawing a connection between the funds paid to Tailored Fund and the accounts receivable that were purchased. Now, the problem with that, under any theory of conversion, there would have to be, well, let me back up for a second. First Financial Bank cannot make a claim against Tailored Fund for conversion simply of the funds that they received from the deposit account, because really it's not possible to convert money. If it's coins in a bag or like some specific money, then there are some limited exceptions, but generally money in a deposit account that's been commingled with other funds is not sufficiently identifiable. It's just black letter law that can't be conversion. And we cited a lot of case law to that effect in the initial summary judgment briefing. And in fact, First Financial Bank made that same argument in another case when S&T Bank sued First Financial Bank for conversion. Okay. What First Financial Bank claims is that what was converted was the accounts receivable, but it's clear that putting pen to paper on the 2 MCA agreements or factoring agreements, whatever you want to call them, that did not cause a financial loss to the bank. And in fact, at that time, the Shining Knight and Wexford were current on their loan obligations. So what First Finance, I agree the theories have shifted. There are so many reasons why there is no liability for conversion, but putting that
Is it possible, counsel, that the theory has shifted because of 332B?
You would have to ask First Financial that. I mean, if you look at the complaint and what's alleged in the complaint, and as Your Honor aptly pointed out in the motion for default judgment, initially it appeared as though the claim was just for the funds taken from the deposit account. And then after we filed our initial memorandum in response to First Financial Bank's motion for summary judgment, that was when, I mean, there was somewhere in the filings where First Financial Bank argued that their quote-unquote primary argument was that it was the accounts receivable that were converted, not the funds. And then at the damages trial and at later stages of the case and on appeal, my understanding is First Financial Bank is saying the accounts receivable are what was converted. Not any that are identified, but some unspecified, unidentified accounts receivable of Shining Knight or the Wexford companies. And they were Tracy Farrell's testimony was very clear. She acknowledged when reviewing First Financial Bank's discovery responses, they're saying what was converted was on March 23rd, 2020, when pen was put to paper on the factoring agreements. And then when we asked in discovery, what are FFB's damages, they state all funds transferred to Tailored Fund from the bank account that we refer to as the 7599 bank account.
And you're saying that those funds, some of those funds also belong to other companies that your client entered into agreements with?
So that is likely the case. It's First Financial Bank's burden to trace. So to back up just a millimeter, as evidenced by the merchant cash advance agreements, Tailored Fund purchased accounts receivable of 18 different entities: Shining Knight, Wexford Place, Wexford Care Center, and then 15 other entities such as Pleasant Ridge Care Center that First Financial had no relationship with. They didn't have a security interest in their accounts receivable.
It all went into the one account.
That's
All of the
correct.
money went into the one account and was paid to your client from that one account.
That's correct. And so, so basically, I mean, the case law on tracing is very clear. What First Financial Bank argued at trial was they said, we traced the funds right out of the 7599 account to Tailored Fund. Okay, but tracing has several prior basic steps where First Financial Bank never met their burden to prove that Shining Knight, for example, ever deposited 1 cent of anything, much less the 1 cent of proceeds of accounts receivable, into the 7599 account. Or even really that Wexford did. I mean, the account was held in Wexford's name, but if you look at the account statements, it's, hundreds of millions of dollars are going through the account. First Financial Bank never proved that Wexford or Shining Knight deposited 1 cent into that account. And when I cross-examined the First Financial's Vice President Tracy Farrell with the discovery requests, I asked her, like, okay, so you're saying there's a connection between the accounts receivable that were purchased from just Wexford and Shining Knight as opposed to these 15 other companies that there couldn't even conceivably be anything wrongful as to FFB of Tailored Fund purchasing. You're saying that those accounts receivable, there's a nexus, there's a connection between those specific accounts receivable and all the funds that were paid to Tailored Fund from the 7599 account. She said, yes, like that was their theory. And it's only logical too, because if Tailored Fund is paid with just random funds in a bank account, then that's not wrongful as to First Financial. There's no way that it could be unless they met their burden to prove they had some kind of interest in those funds, i.e. by proving that those funds were proceeds of accounts receivable of Shining Knight or Wexford.
Well, that's why, so their theory has to be the conversion didn't occur at the time of the payment. The conversion occurred when the agreement was entered into.
That is my understanding of their position.
Okay.
So my understanding is that their position is conversion happened on March 23rd, 2020, when the agreements were signed.
You have 5 minutes
Counsel,
left, but I'm not going to count this against
Can
you.
you address the 332B issue and why we should not follow the Tusa Expo case?
Okay, I'm gonna keep going, and then if I have time left, I'll reserve it for rebuttal. First of all, if you look at the Tusa case that First Financial cites vehemently, Tusa talks about a secured creditor being required to trace proceeds of accounts receivable in a conversion action. It's later on in the opinion. Now, it was in the bankruptcy context, so the burden was kind of reversed just because of the way that bankruptcy cases work. But Tusa stands for that additional proposition. Okay, in terms of Tusa versus Cortland, the problem with Tusa, as explained in Cortland, is that the Tusa court ignored the definition of account and decided Tusa on the mistaken understanding that a deposit account actually contains funds, as opposed to simply being basically a promise by the bank to pay the holder of the account the amount of money that's in the account. And also Tusa, if you read it, it involved this kind of intricate business arrangement where funds were deposited into a lockbox and then into another lockbox, like physical cash. So perhaps in the Tusa context, saying that an account, because I suppose, my understanding is, it was argued that, that was an account, the lockbox with the funds in it. Like, if you want to say that an account contains funds, that makes more sense in the context of a lockbox containing money in it than it does in a bank
Tusa,
account.
there was a subordination agreement as to who would take first and second priority between the creditors, right? And then the court interpreted 332B in accordance with that subordination agreement. But we don't have a subordination agreement here. The two of you are fighting as to who gets first priority. So should the existence of that subordination agreement in Tusa play any role in how we read that case?
Well, it's a distinguishing factor. I mean, I would say Tailored Fund does not have the burden to prove that we have a superior position. First Financial had to prove that we committed conversion, and because the security interest was stripped when the funds were transferred, in addition to all the other reasons why there could not be liability for conversion, that it just precludes a conversion claim. And that's what Judge Barrett has found. It's what every other Hamilton County judge has found. We cited a number of cases from around the country, some actually citing Cortland. The Tusa case is an outlier, and I think that it has some real distinguishing facts. Unless there are more questions at this juncture, I'll reserve however many seconds I've got left for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. Susan Argo on behalf of First Financial Bank. I'd like to just start off by noting that we're not here about a dispute between two secured creditors. I'm very perplexed by all of the hypotheticals that have been posed in the brief by Appellant, citing, we made a loan. No, they're standing here as a purchaser, and they purchased the receivables subject to First Financial's security agreement. I would also submit that the security agreement, it's a red herring argument to be pointing to Shining Knight. The court, in the bottom of page 2 of the decision, properly says that Wexford Care and Wexford Place granted a security agreement. That security agreement covers accounts, all money on deposit, healthcare insurance receivables. And that is expressly a defined term under 1309-102B. And so it's important for this court to realize that these were nursing homes, and that's the sole source of revenue for these businesses. He was running nursing homes, and so healthcare receivables is what funded the business, what was underwritten on the loan, and was what is First Financial Bank's collateral. So the suggestion that we don't have a security agreement in the accounts receivable is just flat out wrong. They never even referenced.
So even if we agree with you, what do we do with the 332B issue in this case?
Yes, thank you, Your Honor. So here's what counsel constantly says. One, as to TUSA, here's what I would suggest to you. In TUSA, it was two creditors. This is a purchaser, all right? And the reasoning in TUSA is this, that the burden should be placed on a buyer to make sure that they're purchasing assets free and clear of liens. And it's not a heavy burden. Run a UCC search. Check to see if there are other secured creditors. What Tailored Fund did is admit that they never did that. They want ignorance to be bliss. They want to ignore the rights of First Financial.
From a policy perspective, I understand what you're saying, but can you address the language of 332B? Because the drafters of that statute have already made a policy determination that might be inconsistent with the policy that you're expressing.
Yes, so if you look at 1309-332B, if you look at A, it says a transfer of money takes free of a security interest, any security interest. If you look at B, which they are relying on, it says a transferee of funds from the deposit account take the funds, and this is very, very important, free of a security interest in the deposit account. It does not strip any other liens. It strips the lien in the deposit account. So First Financial Bank was perfected in two ways. First, by filing its UCC1 financing statement, and therefore it's perfected in the accounts receivable. At the minute they sold that AR, that accounts receivable was converted. This provision does not strip any lien. It only strips a lien in the deposit account. Then I would say Cortland goes on, and I would note for this court that Cortland was appealed to the Supreme Court, and the Supreme Court accepted cert, seeing the errors of Cortland. Unfortunately, that case was settled. But clearly, Cortland is an outlier, and it's not binding on this court. Because what Cortland said...
Well, counsel, it's not an outlier to the extent that its reasoning was adopted by the federal district court here in the Southern District, and numerous other courts around the country have adopted its same holding, including Key Bank, a case that neither of you cited, but it goes into great detail about why 332B was imported into the UCC, the legislative history of Comment 2, and it really sets a foundation for this whole issue. So it's really TUSA that's the outlier, and its predecessor. There's two cases from Texas that go the TUSA direction, and then every other case goes the Portland direction. So what are we to do with that? We've got this split of authority with what I would characterize as a majority going Cortland's way and a minority going TUSA's way. Help me understand why we should go the TUSA direction.
Thank you, Your Honor. Yes, and the reason being is that in Cortland as well, I mean, I would like to back up and say Judge Barrett did remand, and actually we filed an amended complaint and we got into conversion, so like, it's not just, there is the question of collusion and the like, but the policy here is that TUSA, and all of these cases are different as to secured creditors. This is a purchaser. They're standing here as a purchaser claiming that they purchased AR. And then Cortland goes on to say, what is a deposit account? All right? A deposit account is a right of payment from the bank. And then if you look at the definitional section under 1309-102, account does not include deposit account, all right? Account does include healthcare receivables. And then a deposit account is a right of payment from the bank. A right of payment is a receivable. So if you think about it, the receivable, so when the party, Wexford, deposits money, it has a right to demand payment, in this case, from the depository bank, First Financial Bank. That's a right to payment. That's an AR. I mean, so it comes in. That's why banks have absolute sacred right of set-off. And so Cortland says it's a right of payment from the bank and then says it's not AR. What Cortland does is it makes a leap in logic in saying that this right to payment, and then it relies on language in this B that says, oh, I'm stripping the security agreement in the deposit account. It doesn't say it's stripping the lien of the account receivable. And what I would also suggest is when they say—
Counsel, as I interpret that, and I admit Cortland is a dense and difficult case to get through, and I've read it many times to try to come to an understanding of what it's saying. As I read that language in Cortland, what I believe it's trying to communicate to us is that having a security interest in a deposit account is coterminous with having a security interest in the funds in the account for precisely the reason you've identified. That putting money into a deposit account is basically creating a promise that you can get the money back out. And so there wouldn't be a such thing as a security interest in a deposit account without having a security interest in that promise that you can get the money back. Is that making sense?
Your Honor, I'm following to some extent, and I do apologize, but no, trust me, I acknowledge absolutely that Cortland is very fact-intensive. You have to sit, read the code, read the case, and keep going back. But I would suggest that what is, troubling here as well is who is Tailored Fund and the policy purpose. So I would like to get to that. The policy purpose is the free flow of funds. And so, for example, when Wexford paid its employees, those employees should not be afraid of First Financial coming back and saying, oh, that's our money. The landlord or other, those people in the free flow of funds and finality, they should be able to take that money and be paid and not be subject to those type of claims. This is not—
And why is that? How do we know that from 332B? What in the language of 332B distinguishes what we'll call innocent transferees, the landlord, the employees, from TFC?
Because it's done in the ordinary course of business. That's what, First Financial understands, that the healthcare receivables are going to come in, are going to generate it, and that they have ordinary business expenses. It does not state that they get to go off and take— what was going on in the backdrop of this, Your Honor, is a $58 million check kiting. S&T Bank lost $58 million. And so, there is this churn of money coming through. It did not envision Harold Sosna going out and taking loans and selling receivables at 60 cents on the dollar and, just, giving it away. They buried him. That's what caught him eventually.
Isn't that what the collusion exception is for in 332B? But that wasn't pled in this case. So isn't collusion, from a legal standpoint, what might distinguish employees, the landlord, the electric company, from TFC in theory, but it wasn't pled here?
Well, it wasn't— we pled conversion, and then, an affirmative defense is this 1330, so when you look at this, that's the next point that I wanted to make. Look at what they're saying. They're saying we bought the receivables of 18 different companies. All right, those contracts are a sham. They identify a purchase price. They never pay the purchase price. They get that ACH authorization.
But there were no allegations. It sounds like you're alleging fraud right now. But there were no, in this particular case, there were no allegations in the complaint of fraud, correct?
Not in the complaint of fraud, but at trial, we went into this in great detail. We went into 30 days of transfers where they were just pulling money in violation of their contract. They're standing here waiving this contract as a purchaser to you all. And so let's look at that contract. They're a purchaser of 18 companies' various receivables. They want to poke at First Financial and say that we can't trace. How do they know that they took what they purchased? Essentially, they pulled everything out of that 7599 account. How do we know that the other 15 entities, they purchased those receivables? Why didn't they go get the money from them? You know, that's what is going on here. So then they didn't pay the purchase price. They take the ACH. They were withdrawing money before they ever paid a dime. The contract, you know, like there was no exchange or consideration. They just required Harold Sosna to give that ACH form, and on 30 different days, their contract says the maximum that you can pull is X amount of dollars. 30 days, they're just siphoning and debiting and running that money out of that account. And so when you're sitting here looking at the policy and the concepts of this, that's a sham contract. They're standing here and wanting, yeah.
It seems to me like part of what you're arguing is, and that's whether we like it or not, MCAs are legal. And that's often the way that they do their business. So how is this different than any other case?
Well, Your Honor, I guess I'd direct you to the attorney generals in New York and New Jersey where all these folks
I'm talking about
shut down. And then in this case, it's not, they're the purchaser. The burden lies with them, is what Avnet, is what, you know, all of these cases. We have, you know, the Southern District of Ohio weighing in. We have bankruptcy courts weighing in. That Avnet case is directly these facts. And yes, there was a subordination agreement in the end, but that was as between two creditors. And so here, it's not that, you know, that they're illegal, but they're using this as a weapon. And then there's no accountability for them. So because they got an ACH authorization, how is it that they're going to stand before you and suggest that they actually took the stream of payments that they purchased? You don't have to get to court, Lynn. You can look at their sham contract and say you didn't follow it in the least bit, and that's all in the record, and that is argued extensively in our briefing.
How does that factor into any element of conversion? So which element of the tort that you sued on does that fact connect to?
That fact connects to, you know, well, let me just get the elements here. It is, you know, defendant's exercise of dominion or control. They got that ACH form and just started siphoning it off before they ever even paid a penny. You know, over plaintiff's property, we've clearly established that we have a security agreement in the accounts receivable, and we did at the time a deposit account. And then in a manner inconsistent with our rights. The whole point that we're saying here, and that's where when you get to the damages portion of this, and you know, they make these arguments that we have multiple judgments. First Financial Bank is not looking to be paid more than what is owed on the loan. And that's been a windfall even for Tailored Fund. So we were able to show the $3.6 million that were just these ACH debits pulled out of that account. They paid 2.6. And then they have never, and like we're one of the 18. Why weren't they debiting from those other folks? You know, they get away with the fact they were like, oh, we just believed Harold was putting all of the funds from his other companies in there. When is there any accountability under that contract to them? You know, it's extraordinary the way that it's structured. And then they say, haha, we pulled it out and it's free of your security agreement. This policy consideration under the code is not to protect buyers. I mean, you know, it's as if they, you know, bought, you know, Jim's receivables and they're just pulling everything from my account. You know, like there's no form or any formality in which they followed the, you know, followed their own contract. They're standing here as a purchaser and they can't show that they followed it at all. And then, you know, as to our damages, I would say that the First District Court of Appeals, we cited that properly, and it is important under the code. We have the Nonopoulos case where there has to be a nexus for damages. And then As to this tracing element, what's very important as far as that goes is that there's equitable considerations. So to my point of when they require commingling, for them to argue, oh, we've required commingling, it made it difficult for you. There are several ways in which, the bank can deal with that. There's the lower intermediate balance rule. You had asked about all of those. We showed
Counsel,
Yeah.
the damages equation or calculation has changed 3 times in this case. FFB initially sought the amount of the withdrawals, and then next sought the amount of the loan balance, and then finally settled at the damages hearing on the purchase price. Which of those should it be, or should it be something else? What is the actual damages calculation in this case?
Yeah, and Your Honor, the reason why it changed over time is because First Financial Bank recovered other dollars elsewhere, and we're not trying to recover more than we are owed. But the Denopolis case says, an award of damages must be shown with a reasonable degree of certainty in some manner other than mere speculation. And then it says the damages in a conversion action is the harm done to the market to the measure of recovery of which plaintiff would have to replace the lien. And so if you look at it, this is why it's somewhat of a sliding scale, in that it was 3.6, and we were, First Financial Bank was owed more than 3.6 when we filed the complaint. And then it got paid down, and we're not looking for a windfall. That's to the benefit of Tailored Fund. But, then when you look, Tailored Fund, and this reference to the market is what someone's willing to pay for it. And at that time, you have no better snapshot in light of the Denopolis, case in the first district of what price they put on it, is the $3 million. But even at that point, when we were arguing the $3 million, we still never asked for more than what the bank was owed. So, you cite to the $3 million, but we requested $2.6 million. And, the judge said we were only entitled to our principal balance, not interest and fees. But, there is, the nexus, and we've proven the damages. I mean, we watch them just siphon out $3.6 million. And they don't have the right to take, $3.6 million from Wexford. They don't have that right.
Ms. Argo, your time has
Okay.
expired. If you would like to wrap up.
Okay. For this reason, we would ask that the court, affirm the lower court's decision, including the damages amount that was given. Thank you, Your Honors.
Mr. Durst, I gave her an extra 3.5 minutes, so I'm going to credit that to you. You get 5 minutes.
Thank you. Okay, the burden, I want to be very clear, the burden is on First Financial to prove that Tailored Fund converted something that belonged to the bank or something that was proceeds of accounts receivable that the bank had a security interest in. Okay, all these arguments about it's a sham contract, no accountability, they didn't follow the contract, I don't think that was proven at trial. But putting that aside, First Financial made this argument at trial and other similar arguments, like what right does Tailored Fund have to keep this money? Well, the question is whether Tailored Fund converted something that First Financial Bank had a security interest in. If it was a sham contract, what would that mean? It would mean, I suppose, that it's a loan in disguise. Okay, we loaned money to the 18 different SOSN entities and they paid us back. What would prevent us from loaning them money? There may be usury issues in theory, but putting that aside, how would that be wrongful to First Financial? Also, I think it's worth noting, Harold Sosna dealt with Tailored Fund through an attorney. I mean, he was represented, he was a sophisticated party. So if it's a sham contract, then that would mean we just got paid with random funds, whatever funds Sosna chose to pay us with. It is First Financial Bank's burden to prove it's their burden to trace under the statute. They have to trace under one of the 3 acceptable tracing methods under Ohio law. They did not do that. In the opening statement, First Financial Bank appeared to argue that they shouldn't have to trace, that it's ridiculous that they should have to trace because the contracts required commingling. Regarding the MCA agreements required commingling, okay, they require all the receivables from all 18 companies, which we don't know.
Counsel, from reading the other 332B cases, it appears that this commingling phenomenon is an industry standard for MCAs. It looks like from the facts in those other cases that MCA agreements often require an entity and an MCA agreement to put all of the funds in one place so that the MCA company can debit it out from just one account. Is that your understanding as well?
Yeah, that's absolutely correct. Sometimes if it's a merchant that is processing credit card transactions, then the money comes from the credit card processing company where it's held. But absent that, yes, that's the typical practice. And okay, these agreements, they didn't require SOSNA to commingle the funds, the receipts of the 18 different entities with other funds. I mean, it required them to put them all into one account. But okay, the question I suppose the trial court asked was, is it fair, because the contracts require commingling to some degree, is it fair to make First Financial trace? Okay, the legislature has answered that question, and per 1309.315, the answer is yes, they have to trace. There's no exception provided in the statute for, if it would be difficult, then they don't have to trace. Or if the defendant did something that they claim was untoward, they shouldn't have to trace. What the trial court did here was award over $1 million in damages against my client by basically just assuming, without First Financial Bank meeting its burden to prove, that even 1 cent, by First Financial's own admission, that even 1 cent came from receivables of Shining Knight or Wexford. Don't kid yourselves. First Financial absolutely could have traced. Okay, they could have. It's done in tons of cases.
I was curious how difficult that would be.
So it's done in other cases. They were requesting almost $1 million in attorney fees across all these cases. They most certainly could have traced. There are financial experts you use. Tracing comes up in divorce cases a lot. It comes up in a lot of contexts. And it's just an analysis that has to be undertaken. And we would submit that given what we know now, which neither the bank nor Tailored Fund knew about Harold Sosna and what he was doing with his check kiting and all the advances from other MCA companies, I would be willing to bet that if that analysis were undertaken, that it would basically disprove First Financial's case. But we don't have to guess about that because it was First Financial's burden. We argued it early on in the case, in the briefing. We had a damages trial. They had every opportunity to trace. I mean, we had thousands and thousands of pages disclosed in discovery. The bank accounts are even kept at First Financial Bank, some of them. So we would submit that the issue is very simple. First Financial did not trace. They didn't satisfy the tracing statute. The trial court erred by perplexingly just stating in the decision in one sentence the proceeds are identifiable and traced, when Tracy Farrell says, no, I can't identify even 1 cent of the transfers that I can specifically trace back to Wexford or Shining Knight's accounts receivable. So is my time up?
Your time is up.
Okay. All right, we would respectfully ask that this court reverse the trial court's decision. Thank you.
Thank you.